Hi, this is Steve Dans. Thank you very much for joining our employment law video series here on YouTube. And today we're going to talk about some side issues that don't generally come up in the nuts and bolts of employment law, but they're things that you should keep in mind as you consider litigating or working towards a settlement offer with a prior employer. And I borrow it from the title of today's video from a late night TV host who has a new section called Meanwhile, and it has to do with news that is not necessarily on the front page, but which is of extreme interest to all of us who follow the news. So we're going to talk just about a couple of different items in today's short video. I think you'll find it interesting and hopefully helpful as you consider whether or not to move forward on your own employment case. The first thing to keep in mind is that many other defendants, meanwhile, are possible targets for a settlement demand or actual litigation. Many people think only the company they work for can be sued. But think about this. Number one, individual supervisors and managers may engage in conduct that, at least under California law, subjects them to liability. The advantage of suing an individual is, in many cases, the availability of punitive damages, which may not be available against the employer, depending on whether they're, for example, a public entity or something else. The other advantage is that a resident of California will keep a case in state court. So if that individual supervisor of yours is a resident of California and is a legitimate defendant, then the case is not likely going to be removable to federal court. So keep in mind other defendants include temp agencies, payroll agencies, personnel agencies. Many times they're part of a conspiracy to hide from you everything you should have known before you took the job. And there can be aiding and abetting, civil conspiracy, joint and several employment for these other defendants. So it's a complicated area of law, well worth looking into though. The second part of today's short YouTube video will be about creative fixes for procedural problems that you may have in your lawsuit. For example, you may take your case to an attorney who says, well, it's a nice wage and hour case, we understand you suffered damages, but there's really not enough to bring in a big law firm such as ours, where there might be thousands of dollars of costs involved just to settle it for probably the same amount. So we start to suggest and think about class actions. Would the employer pay you more in order not to have to face a probable class action down the road? And there are different levels of class actions. That's the other thing to consider. Many times, for example, a labor code violation claim will come up under what we in California call PAGA, Private Attorney General Action. Very simple to do, gives the employee a lot of leverage. So you want to think about PAGA and overall class actions generally as part of your settlement. The other area to consider are the threat of multiple arbitrations. Right now, today, approximately 65% of our Fortune 500 defendant corporations that we routinely litigate against have binding arbitration agreements for employment. We try not to make them binding. If they missed a procedural clue in it, then we're going to get it thrown out of court and you'll be able to have your jury trial. But many employers have been faced with the threat from credible law firms of multiple arbitrations brought on behalf of each person. Our latest information shows that an employer can spend anywhere from $15,000 to $50,000 on an arbitration for just one employee, such as yourself, because the law requires in California that they pay all of the expenses unique to that arbitration panel. And arbitrators can easily charge $5,000 or $10,000 a day. So the threat of multiple arbitrations properly postured is definitely something an employer should keep in mind. There are a few of the issues. The next video we're going to be talking about some creative fixes in terms of what you can ask for, which the employer might want to consider. You always have the right to ask for reinstatement, at least under government code or discrimination claims, and employers will pay a lot many times not to have an employee have that right. So that's one more card that can and should be played. There's a lot of good employment law firms in California. we recognize and appreciate the time you've spent with us. We'd love to be able to consult with you, and our contact information is here, Stephen Bands and Associates. Thank you.